Hello friends, Namaskaram. Myself is Dr. Jinesh Soni. I am an advocate and a corporate lawyer. Today we will discuss in detail about the practical application of section 35 subclause 3 of BNSS. You know, BNSS stands for Bharatiya Nagarik Suraksha Sanhita. Before the said legislation we are having CrPC. In CrPC we are having 41A. Section 35 subclause 3 is resemble with 41A of CrPC. 41A of CrPC inter alia provide protection for the arrest, but the key point is that at the inception, when the said provision was incorporated in CrPC, even the police was never shown the willingness to comply with the same. For the first time, Honorable Supreme Court in case of Jinesh versus State of Bihar had interpreted section 41A CrPC and specified that the arrest should not be made in the mechanical manner. If the concerned police is going to arrest the concerned accused in that scenario, even in the arrest memo, the reasons are required to be given. If there is no reason, the arrest cannot be said to be justified. Even the concerned magistrate is duty bound to scrutinize whether the arrest is made in the routine way or as per law. If it is found that the arrest is done in the mechanical way or in routine way, in that scenario, the arrest would be illegal and it could be turned down due to the principle of quashing and set aside. And apart from that, in that scenario, the liberty of the accused is required to be restored, means he deserves the bail. As we know that there are two provisions which are inter alia contrary to each other. One is arrest while other is bail. The arrest inter alia takes your liberty and the bail inter alia gives you the liberty in the form of restoration. So basically we are having two important judgments of Honorable Supreme Court. One is Jinesh versus State of Bihar, other is Siddharth versus State of UP. In that case, it is specified that the arrest basically affects the reputation of a person. Because arrest, even though made in the mechanical manner, could have a great damage to the reputation of a person, and that's why it is usually advised not to do the arrest in the mechanical way. There must be some justification. If there is no justification in that scenario, arrest would be illegal. The power of arrest is one thing and its exercise should be lawful. If it is not found to be lawful in that scenario, definitely it will prejudice the rights of accused. We should remember that the accused is also having human rights and he deserves the protection of Article 21 of Constitution of India. Even though a person is accused in that scenario, there is no waiver of such rights. Section 35 subclause 3 is basically resembling with section 41A. It says that the police officer. The key point is that the benefit can be given by police officer only, not by a judge. Second part is that shall. Shall means it is imperative protocol. He cannot exercise the discretion, he has to apply the same. Apart from that, in all cases, whether it is in anti-corruption or B.N.S.S. or any other law for the time being in force, if the arrest of the person is not required, so that is too much technical in nature. The key point is that the arrest is to be done only when there is an evidence that the accused is going to tamper with the evidence, going to abscond or flee away from justice. Apart from that, there is an evidence that the accused is going to cause the disappearance of evidences, and apart from that, he is going to compel or threat the witnesses in various ways. Apart from that, he has committed the cognizable offense. If not prevented, he might repeat the second offense. In that scenario, arrest is sine qua non. For this, you may peruse section 35 of B.N.S.S. But apart from that, in the arrest memo, the reasons are required to be given. It is also specified in the statutory provisions. So basically, if the arrest is not required and apart from that we are not falling in the set categories, in that scenario we deserves a notice. In the notice there will be a direction in which the accused means a person against whom a reasonable complaint has been made, that is point number 1, or credible information has been received, point number 2, reasonable suspicion is in existence, point number 3, that he has committed a cognizable offense. So when the said protocol is not satisfied, in that scenario notice is not required to be given. Apart from that, arrest is not required to be done. The key point is that the said notice is intrinsically connected with the offenses that comes within the preview of cognizable offense. If the offense is non-cognizable, in that scenario the notice could not be given. In the notice, direction will be pertaining regarding the appearance before the official or the concerned investigating authority, and apart from that there must be a specification regarding place, date and time. If the said specifications are not given and apart from that notice is not given, in that scenario you may move for anticipatory or for quashing. Because giving notice is imperative, if there is non-legal compliance you may chalk out the case, because due to non-giving there is an apprehension that in a false case you might be arrested. So in that scenario you may seek the legal protection as per law. The key point is that sometimes it is seen that the concerned authority is not willing to comply with section 35 subclause 3. In that scenario, I am giving you 5 important practical tips to be noted. Number 1. In case there is an offense in which FIR is registered, first of all you have to see the nature of case and the term of imprisonment. Even though you are not a law student or a lawyer, in that scenario just open Google, mention the section and then specify the nature, whether it is cognizable or non-cognizable. And apart from that you have to find out the term of imprisonment, which is also available on Google. So in a simple way we can find out the nature and the maximum term of imprisonment. And if you are a law student or a junior lawyer, then you may prefer B.N.S.S and B.N.S. And apart from that, if there is any other law apart from B.N.S, then you have to find out that particular legislation which is available on Google itself, and you can find out the term of imprisonment. Number 2, if the imprisonment is less than 7 years, and apart from that the offense is cognizable, in that scenario you deserve the benefit of section 35 subclause 3. Point number 3, there might be a condition that police may say that you are not cooperating, for which you have to follow the basic principles laid down by Honorable Bombay High Court, an important judgment titled as Chandra Kochar versus State of Maharashtra and CBI. In that case it is specified that if accused is cooperating even through by the virtue of supplying information through email, WhatsApp, in that scenario it is sufficient compliance. In the practical way, it is requested to submit the reply to the FIR so that your stand could be on record. And apart from that, you may inter alia communicate with the concerned police whether they are willing to serve this notice to your client or not. And if the notice is not served, in that scenario it is a very good case to have proper cause of action. You may specify the reasons for not attending the station. In that scenario, there will not be any adverse inference as per section 119 of BSA. BSA means Bharatiya Saksha Adhiniyam. Point number 4 is that you have to specify each and every ground why the litigation is false and why it deserves to be dropped. So basically it is called representation. And point number 5 is that you have to specify that you are willing to join the investigation. You are also willing to be present before the IU for the purpose of interrogation. And apart from that, you deserve the right that your advocate should be present in case you are kept in confinement during the course of interrogation. So in this way, you may preserve your right and could bring the proper position before the concerned police. In case there is a non-compliance, in that scenario, you may specify to the court that despite of specifying to the concerned police is not showing any willingness to comply with the legal provision, and that's why there is a need of protection. So whenever you are totally able to show that you are not absconding, you are not having any intention of fleeing away, in that scenario you may get the benefit. So I think that in the present class I am totally able to cause all of you to understand the basis of section 35 subclause 3 of BNSS. If you are having any query, please mention in the comment and I will try to answer the same in my next video. See you in the next topic. Till then, Jai Hind, Jai Bharat.